Okay, welcome to this explainer. Let's just dive right in and unpack exactly what your rights are when that brand new car turns out to be a total dud. We have all heard the horror stories, right? So today, we're going to lay out the hard facts regarding the Michigan lemon law. I want you to picture this. You just bought an exciting, brand new vehicle. You drive it off the lot with that incredible new car smell, only to find yourself constantly taking it right back to the dealer. You're sitting there drinking their terrible waiting room coffee because they just cannot fix a major defect. It literally goes from a dream purchase to an absolute nightmare. But listen, you are not powerless here, and we're going to show you exactly why. Here is our roadmap for today. 1. What is the lemon law? 2. Do you qualify? 3. Busting lemon law myths. And 4. Steps to strengthen your claim.
Okay, part 1. What is the lemon law? Let's establish exactly what protection you have in your corner.
So, fun fact, the official legal name isn't actually the Michigan Lemon Law. It's officially known as the New Motor Vehicle Warranty Act, and it's been on the books since 1986. The entire purpose of this legislation is to protect you, the consumer, from the massive financial loss of buying a defective new vehicle. It ultimately ensures that if a manufacturer can't fix a substantial defect after a reasonable number of attempts, you aren't just left holding the bag.
Here's the real kicker. If you meet the specific criteria we're about to discuss, the law literally forces the manufacturer to make you whole again. You aren't stuck trading it in at a massive loss. You could be entitled to a full refund of your purchase or a comparable replacement vehicle. That is incredibly powerful leverage.
Moving on to part 2. Do you qualify? Let's see how this builds into a strict 3-part system.
To get that refund, you have got to check all 3 of these boxes. First, it must be a qualifying new vehicle. Now this covers new passenger cars, trucks, SUVs, and vans purchased or leased right here in Michigan for personal or household purposes. Interestingly, business buyers are covered too, but only if they buy or lease fewer than 10 new vehicles a year. Second, it has to have a substantial defect. And third, the manufacturer must have had a fair chance or a reasonable number of attempts to fix it. Let's drill down into those last 2.
So what counts as a substantial defect? Well, a rattling cup holder or a tiny scratch on the dash, yeah, that won't cut it. Minor annoyances or cosmetic issues simply do not count. A substantial defect has to meaningfully impair the vehicle's use, value, or safety. We are talking about serious, fundamental issues here. Engine trouble, a failing transmission, brake problems, major electrical faults, or steering issues.
Now, how do we define that third box, reasonable repair attempts? You obviously don't have to give the manufacturer unlimited tries to figure it out. You automatically hit the legal threshold if the exact same substantial defect has required 4 or more repair attempts. Once you hit 4 strikes on the exact same issue, the legal burden shifts completely away from you and directly onto the manufacturer to prove the vehicle isn't defective.
But hey, what if it's not the same issue 4 times, but rather a car that just seems to live at the dealership? Well, alternatively, you also hit the threshold if the vehicle has been out of service for repairs for 30 or more cumulative days during the warranty period. It doesn't even have to be 30 days in a row. If it spends a week here, 2 weeks there, maybe a few days later on, and it all adds up to 30 days out of service, you have checked that third box.
But hold on, because there is a massive catch here that you absolutely must pay attention to. You have to act fast and document immediately. A key timing rule dictates that the defect must first appear within the very first year of ownership or during the manufacturer's express warranty period, whichever comes first. Because if you miss this 1-year warranty window, you risk losing your lemon law protection entirely.
All right, part 3, busting lemon law myths. Let's pivot to some major misconceptions that leave buyers incredibly frustrated.
Myth number 1, the infamous 3-day cooling-off period. So many people mistakenly believe they can just return a car within 3 days if they change their minds. Let me be crystal clear. Michigan law does not provide a cooling-off period for new or used vehicle sales. Once you sign that contract, it is final. You cannot cancel the purchase simply because of buyer's remorse.
Another huge myth is that the lemon law protects you when buying a used car. The reality is, the Michigan lemon law primarily protects new vehicles and certain qualifying leased vehicles. Unless a specific dealer voluntarily offers a return policy, which is a business policy, by the way, not a legal right, where there's some remaining manufacturer warranty, buying a used car as is literally means exactly that, as is. You are entirely responsible for repairs once you drive it away.
And myth number 3, the strict 12,000-mile limit. You might hear this thrown around a lot when researching this topic. While some states do have odometer caps, and some resources cite 12,000 miles just because many drivers hit that within a year, the Michigan lemon law itself explicitly relies on a time-based window. It's the 1-year or warranty period window that controls your claim, not some strict cap on your odometer.
Okay, finally, Part 4, Steps to Strengthen Your Claim. Let's outline the exact steps you need to take.
When it comes to the timeline, this is your absolute blueprint. Michigan law demands you give the manufacturer one final opportunity to fix the car. You do this by sending a written notice by certified mail with a return receipt requested. But listen, you don't wait until the 4th attempt or the 30th day to send this. You send this letter anytime after the 3rd repair attempt or after 25 cumulative days out of service. Once they receive it, they must direct you to a repair facility, which triggers a strict 5-business-day countdown for them to resolve it. If it's still broken after those 5 days, you may be entitled to your refund or replacement.
Now, to make this process work, you have got to be meticulously organized. The stronger your paper trail, the easier it is to prove the burden is shifted back to the manufacturer. So save absolutely every single receipt and document. Keep every repair order, all correspondence, those certified mail delivery confirmations, and keep your own running notes on exactly when the defect occurred and how it affected your drive. Good documentation really is the silver bullet for your claim.
But what if you don't fit the lemon law? Say you bought a used car and the transmission fell out on day 2. Remember, even if you don't qualify under the lemon law, fraud is an entirely different ballgame. If a dealer knowingly concealed defects or misrepresented the vehicle, you may still have recourse through Michigan's Consumer Protection Act. Fraud is definitely not buyer's remorse, and it has its very own set of legal remedies.